I stood before the property, the culmination of 3 years of joint planning with my husband, David. Intended as our marital residence, ownership had been transferred to his associate, Amber, for a nominal sum. As Rebecca Mitchell, a 35-year-old real estate attorney, this development represented a significant personal and professional challenge. I observed David preparing to depart, his demeanor indicating satisfaction. "This action is unacceptable," I stated. "We developed this property collaboratively." David responded, "I manage the construction and associated documentation. My name is on record. You prioritized your legal practice, deferring the administrative tasks to me." His statement regarding my professional focus was accurate. I had granted him oversight of the construction process while I concentrated on my legal practice, relying on his management. "Could you confirm the transfer was executed for $1? I inquired. David's confidence increased. "It is a legally recognized transaction, Rebecca. You are aware that $1 constitutes valid consideration for property transfer. The deed has been recorded, leaving you no apparent legal recourse." I considered the document I had located hours prior, embedded within the construction files. David had misjudged the thoroughness of my review. "That is correct," I replied. "The deed has been recorded in its entirety." My statement prompted his pause. He looked up, and his question lacked his previous certainty. "What is the implication?" he asked. "None that I will articulate now," I responded, moving towards the exit. "I anticipate you and Amber will find the property satisfactory. However, a comprehensive review of all associated documentation is advisable before establishing residence." "What associated documentation?" he called out as I exited. I elected not to provide further details. Upon returning to my office, my focus shifted to the catalyst for this situation, which had occurred 2 weeks earlier. While working late, a colleague approached, presenting a document with apparent concern. "Rebecca," she began, "I believe you should review this." The document was a property transfer deed, conveying my residence from David to Amber Collins for $1, dated 3 days prior. Reviewing the document, I initially felt disoriented. This rapidly transitioned to professional determination. As a real estate attorney, I recognized that David's attempt to manipulate a transaction within my area of expertise would have significant ramifications. I dedicated the following 2 days to a comprehensive review of all property construction documentation. David had managed all administrative aspects, citing efficiency and his oversight of the build. I had concurred, extending my full trust. Within these records, I located a transformative provision, a clause within the property deed that David had evidently overlooked. It was a standard requirement in custom construction projects in our jurisdiction, mandating that any sale below market value within the initial 5 years would initiate an automatic review by the county assessor's office. This review was not standard. The clause specified that in such an event, the property would be reassessed at its current market value, and the differential between the sale price and market value would be subject to an immediate tax assessment payable by the seller. The property's market value was assessed at $2.8 million. David's transfer for $1 resulted in a substantial tax liability assigned solely to him. Furthermore, this critical clause was embedded within the deed restrictions, which transferred with the property. Amending this restriction would necessitate my explicit consent. I anticipated David's understanding upon receiving formal notification from the county assessor's office regarding the pending tax assessment. A message from David appeared. "What did you do?" I elected not to respond, focusing instead on an additional document I had located. This document was a bank statement detailing transfers from our joint account to a separate account held in David's name. He had been systematically diverting funds, evidently in preparation for separation. However, a critical error had been made. He had utilized our joint account to finance the property's construction. Every expenditure related to the house could be traced back to our marital assets. In this state, this established my claim to 50% of the property's value, irrespective of the name on the recorded deed. Another message arrived. "Answer me, Rebecca. What associated documentation?" I placed the device aside and accessed the county assessor's website. As anticipated, a notice of review triggered by the recent transaction was posted. Official notification would be issued to David imminently. My phone began to ring. David's contact information was displayed. I directed the call to voicemail, allowing him time to consider the implications. The remainder of the afternoon was dedicated to preparing the necessary legal documents: a claim for division of marital assets, a petition for an emergency injunction to preclude any further property transfers, and a detailed accounting of all expenditures incurred during the property's construction. By the conclusion of my work, I had received 7 missed calls and a dozen increasingly urgent text messages from David. The final message stated, "You were aware of this. You knew this would occur." Naturally, I possess prior knowledge. As a real estate attorney specializing in property transfers and tax law, safeguarding my interests was a professional imperative. I drove to the apartment, a property I had insisted on retaining even after the house was completed, a decision David had initially opposed. As I parked, I observed David's vehicle and noted his presence by the entrance, his earlier composure replaced by evident anxiety. "Do you comprehend the consequences of your actions?" he demanded as I approached. "The tax assessment. It significantly exceeds my income over 5 years." I entered the building access code, disregarding his statement. "That outcome is a direct result of your decisions. You must facilitate the resolution," he insisted, following me. "You possess the authority to release the deed restriction. Please, Rebecca. This could result in financial ruin." I turned to face him, observing his distress. The individual I had been married to for 12 years, who had committed a profound breach of trust, was now requesting my professional intervention. "You have already incurred significant loss," I stated calmly. "You forfeited your position the moment you elected to transfer our intended residence to your associate. The tax assessment is a direct consequence." "I will dispute it," he asserted. "I will state I was unaware of the clause." My response was direct. "Proceed. You executed the deed. As a businessman, David, you are legally presumed to have reviewed and understood the documents you sign. Presenting an argument to a court that you transferred a $2.8 million property for $1 without reading the deed restrictions is unlikely to be favorably received." The full implications of his predicament became evident to him. "What is your requirement?" he asked. "I require nothing from you," I reiterated. "You made your decision. Now you will accept the consequences." I unlocked my apartment door and entered, leaving him in the hallway. Through the closed door, I heard his inquiry, "What about Amber?" "She cannot afford the property taxes either. Then she will presumably need to liquidate the asset." I replied, "I anticipate she will realize a value exceeding $1 from that transaction." I closed the door to end the interaction. The initial phase of my strategy had been executed. David had acknowledged the significant tax implications of his actions but remained unaware of the subsequent legal proceedings. The following day, he would be served with my petition for division of marital assets. Subsequently, he would be informed of the emergency injunction preventing further property transfers. By the end of the week, the full extent of his financial jeopardy resulting from his attempt to conceal joint funds would become apparent. My phone signaled another message, a text from David stating, "We can reach a resolution. Please." I made an error. I silenced my device. David's assessment was accurate. He had made multiple errors. However, his most significant miscalculation was underestimating my professional capabilities. I seated myself at my desk and reviewed the compiled documents, every bank statement, every construction receipt, every transfer record from our joint account. Collectively, they presented a documented history, a record of his actions, which demonstrated both a disregard for fiduciary responsibility and significant operational negligence. David's focus on his alternative relationship had led to a lack of rigor in handling critical details. And details, as any competent legal professional understands, are fundamental. The following morning, I arrived at my office prior to regular hours. 3 sealed envelopes containing the legal documents prepared for service upon David were on my desk. I reviewed my phone. 5 additional missed calls and a series of increasingly frantic text messages from him. "The county assessor has contacted me. The tax liability is $980,000. Please facilitate a resolution. Amber is distressed. She cannot afford the property taxes. We can discuss terms. Name your price." I placed the device aside and accessed my computer. County records confirmed the official recording of the deed transfer to Amber. This established her legal responsibility for ongoing property taxes, while David remained liable for the transfer tax assessment. My assistant knocked and entered. Rebecca, your 9 a.m. appointment is here. I acknowledged, adjusting my professional attire. Send him in. Marcus Chin, the forensic accountant I had engaged, entered, carrying a substantial file. The findings are conclusive, he stated without preamble. The financial trail is unambiguous. Your husband not only utilized joint funds for the property but has systematically transferred assets over several months. He presented supporting documentation, bank statements, transfer records, investment account summaries. David's financial planning had commenced earlier than initially estimated. Significantly, Marcus continued, his attempts at concealment lack sophistication. Every transaction is documented. He routed funds through your joint account, possibly believing it would complicate tracing. Instead, it provides a comprehensive transactional history. I acknowledged the information with professional resolve. Total value of diverted assets exceeding $3.2 million, exclusive of the property value. The magnitude of the figure was impactful, representing years dedicated to building shared financial security, contrasted with his strategic appropriation. My phone vibrated again, displaying a text from David. The bank is initiating account freezes. What action did you take? My action had been filing a request for an emergency asset freeze as a component of my divorce petition. Given the presented evidence of his financial maneuvers, the court had granted the order immediately. The timing is favorable, Marcus commented, organizing his materials. Many of these transfers occurred after his relationship with Amber commenced. This supports a potential assertion of premeditated financial misconduct. I thanked Marcus and accompanied him to the door. Upon returning to my office, a new email from the county assessor's office was present. They had finalized their review of the property transfer. The official tax assessment was scheduled for issuance that day. Promptly, my phone rang. It was Amber. Miss Mitchell. Her voice registered significant anxiety. I need to discuss the property with you. You are referring to the property registered in your name, I responded, maintaining a professional demeanor. The one you acquired for $1. I was unaware, she stated quickly, about the tax implications. David never informed me. I cannot afford the property taxes and financial institutions will not extend a loan because... She hesitated. Because you possess no equity in the property, having acquired it for a nominal sum, I completed her statement. Please, she pleaded, her voice strained. I am uncertain of the appropriate course of action. David states his accounts are frozen, and I do not have access to those funds. Considering the situation, I advised. Selling the property is your most viable option. The property taxes are due within 30 days. Executing a sale now would allow you to utilize the proceeds to settle the tax liability and retain the remaining capital. But will David not be displeased? She inquired. David's emotional state is no longer your concern, Amber, I replied directly. He involved you in a transaction that did not proceed as intended. My professional recommendation is to divest of the asset promptly. After a noticeable silence, she responded softly, he stated you would attempt to regain ownership of the property. That was his rationale for transferring it to me. My objective is not ownership of that specific asset, I clarified. My objective is to secure a just resolution in the broader legal matter. Currently, you are positioned within a complex legal process that is poised to escalate significantly. Your course of action should be to sell the property, fulfill the tax obligations, and transition to the next phase of your life. The asset did not perform as anticipated. The recommendation was to divest the property promptly. Following a pause, she indicated that David had anticipated this action, citing it as his reason for transferring the property into her name. The response clarified that the objective was not ownership, but a just resolution to a complex and escalating legal situation. The proposed course of action was to sell the property, satisfy the tax liabilities, and move forward. Subsequent to the call, it was evident that David's prior arrangements were failing. Legal proceedings commenced shortly thereafter. David secured legal representation from a reputable local attorney. However, the extensive financial records he had generated, meticulously documenting every transaction, account, and asset concealment attempt, proved undeniable. The transfer tax assessment was confirmed at $980,000, payable immediately. David's counsel contested the deed restriction, arguing it was unconscionable, but the court rejected this argument, citing the clause as standard local practice and noting David's voluntary signature. Approximately 1 week later, Amber contacted me to confirm her decision to sell the property. She reported securing a buyer at market value. She noted David's strong negative reaction and claims of disloyalty, stating she felt no obligation to him given the circumstances. It was conveyed that she was not indebted to him and that he had utilized her position for his objectives without considering her potential consequences. Following the call, analysis of financial records provided by Marcus confirmed that David's attempts at asset concealment had inadvertently created a clear financial trail, supporting an equitable division during divorce proceedings. The property sale concluded 2 weeks later for $2.9 million. Proceeds were used by Amber to cover the property taxes, and she retained funds to relocate. Information received indicated her return to Oregon. David simultaneously confronted the consequences of his actions. The tax obligation substantially reduced his liquid assets, and the divorce process exposed the full extent of his financial misconduct, resulting in significant damage to his previously respected professional reputation. During the review of settlement documentation, messages were received from David. The first stated, "You have dismantled everything I constructed." A second message followed, "I had not anticipated this level of opposition from you." No direct response was formulated. David's actions indicated a misjudgment regarding the narrator's capabilities and legal knowledge. The final divorce settlement resulted in an equal division of marital assets as required by law. David's attempts to conceal funds unintentionally reinforced the legal position, necessitating full disclosure of all accounts and transfers. 6 months subsequently, the narrator achieved partnership at her firm and was established in a new office. A message from a sister reported seeing David, noting he appeared distressed, and inquired about the narrator's well-being. The response conveyed a status of being more than all right and free. The outcome demonstrated resilience and the successful resolution of the situation.